Yes! Hello, my beautiful friends. What an amazing day it is today. We've got the Brian Cole Jr. J6 detention hearing, might be a preliminary hearing. This afternoon, we're going to be in attendance and we'll be back with an update later. But we've got some new filings that dropped over the evening break. We're going to get into it, quick preview, then we'll circle back and dive in. We got 3 segments today and a lot to get to. So starting out the show, we've got this filing that just dropped from Brian Cole Jr.'s defense team. Of course, this is the alleged J6 pipe bomber, and his defense attorneys are now confirming for us that he is in fact autistic, level 1, and he's got OCD, which might be the reason why he was deleting and wiping his cell phone almost 1,000 times. So we'll go through this today because, as we talked about yesterday, the defense team is saying that today should be the day of the preliminary hearing and the detention hearing, 2 in 1. And the government, the DOJ, is saying, no. It's just the detention hearing. But the defense is submitting interesting filings. We also have some character reference letters that have come in saying Brian Cole Jr. couldn't do something like this. He's autistic and he's not capable of doing something like this. Of course, we'll see what they say about it, see what the defense says, and we've been patiently waiting to see whether the judge is going to give us a ruling or not on what's going on in court today at 1 p.m. And so we'll keep our eye on that. As it stands, the prosecutors might be having to get prepared for both things in case the judge does come down and say, we're having a preliminary hearing today. That's a big deal. We'll have officers, cops, FBI agents come in and testify. So we'll see what goes down. But they are releasing some information about him today, and it is curious. So we'll go through it. We'll see what you think about all of it. Coming up. Then we got another unsealed filing to attend to. We love it. You see, this one is in the case of Tyler James Robinson, the assassin, allegedly, of Charlie Kirk. We had a big battle over a secret hearing. There was a proceeding that occurred October 24th. Nobody knew anything about it. And it was done behind closed doors. Then the media came screeching in here saying, you can't do this. We're the media. We have a right to intervene in these cases. We heard a lot about that yesterday, but the judge has now unsealed the transcript from the hearing, and there are some redactions in here. So we'll go through it. We'll see if we can parse through the redactions and see what they actually mean and break down what went down back on October 24th. A lot of it is not that interesting, so we'll fast forward through some of it because it's about the sheriff and standing and whether he can intervene. We've already discussed most of that, but there are some interesting redactions, and we've got questions about really why they're so concerned about pretrial publicity that would be so harmful to Tyler Robinson. We know that many others have gotten a bunch of pretrial publicity, like Derek Chauvin and Kyle Rittenhouse, and the courts didn't twist themselves into pretzels to lock down those trials. They wanted them really convicted in the court of public opinion. So the question is, are they doing the opposite with Charlie Kirk's alleged assassin, Tyler James Robinson? So we'll get into that, all of it now unsealed, courtesy of the judge. We're happy about that. And then lastly, we'll close it out with some Minnesota updates, because in Minnesota, a bunch of Senate Republicans, look at all these signatures over here. That's a lot. They're all saying Tim Walz needs to resign. Okay, enough is enough already. And that's just a good start. Probably should be in prison. But senators coming out of the woodwork there in Minnesota demanding action. We also have Tom Emmer, the GOP majority whip, also digging in on this. Pam Bondi came out, said, we're arresting everybody. We'll go through, we'll look at what she posted, and shout out to our friend Nick Shirley. This is not Nick Shirley's account. She tagged the wrong account, but that's okay. We'll go through that. Nick Shirley knows that he's responsible for a lot of this attention. But we've also got more. The mainstream media is not covering this. ICE is being deployed, Homeland all over the country. Tim Walz is posting pictures of his cat. And James Comer is out saying Congress is really looking into this. So we've got a great stream planned ahead. We're very glad that you're with us. We're here early. We're in Washington, D.C. We're traveling around. And today we're going to the federal district court in Washington, D.C. for the Brian Cole Jr. detention hearing, maybe preliminary hearing, and then we'll record a video after that immediately as soon as that's over with some updates on what we saw, because he's going to be in there presumably, walking around, moving around, and we're going to do the old compare and contrast to see if it matches any of those other surveillance videos that the FBI released that are 1 frame per second all over Washington, D.C. So we're going to have a great stream. Members, stick around. We're going to do an after party after the show is over. See what else you have to say about this, what else is cooking. As the clock counts down on the final days of 2025, 26 right around the corner, going to be a fresh new year with that fresh New Year smell, and we're looking forward to that. So thanks for being a member. Thanks for sticking around after the show on Locals on YouTube. We'll hang around and take some additional comments and see what else you have to say about all this stuff and more. So it's going to be a great stream. Happy Tuesday. Happy December 30th. Final days of 2025. We're looking forward to a fresh new year. Now, let's get into business on the day, because we got a lot to get to, starting right now with Brian Cole. The alleged J6 pipe bomber, now confirmed to be autistic. This is what his defense team is writing in a new opposition to a detention hearing and a request that the government submitted to the judge saying, do not let this guy out of custody. He's a bomber. He was going to blow up the RNC and the DNC. Well, the defense says, actually, you kind of misinterpreted a lot of the facts surrounding this case. So they dropped this one in. It's an 18-pager, and they do confirm autism and OCD, and we're going to learn about what level autism he is and what that actually means. Does that mean you can't place a pipe bomb? The prosecutors will say, so what if he's autistic? He can drop bombs off, can he? So we'll unpack what it means, but let's see what the motion says, because we've also got some follow-up here from a bunch of people who are submitting letters of character reference, basically mitigation-type letters, to say, you're misinterpreting this dude completely wrong. The DOJ came out and has one framing, but there's a whole other side to this story. And so we know that as of yesterday, the DOJ submitted their motion saying we have to keep this dude in detention. They explained to us they did about a 4-hour plus interview with him without counsel. He, after about 2 hours, as we saw in the motion, of interrogation, he then put his head in his hands. He's like, ugh. Did you do this? He goes, ugh. Yes. And then they came back out and they said, well, since you just admitted that you did it, you can even either tell us the rest of how you did it, or you can go to jail right now. Do you want to stay and talk to us, or do you want to go to jail right now? He said, sure, I'll talk to you. And then the rest is history. Kind of started to spill his guts and said, no, he concocted this. He learned about creating the pipe bombs, watching YouTube videos and playing video games or something. Then, of course, they booked him. They came out aggressively saying, he admitted everything. We got the guy, it's clear as day. Now the defense is responding to their motion, and they say, all right, Judge, listen, Brian Cole Jr., the alleged pipe bomber, he respectfully submits this response to the government's demand that you hold him in pre-trial detention. He should be released. There are rules around these things, and if you just do a multi-factor analysis, you're going to find out very clearly you should let him out. They say the defense understands that the detention hearing will begin with preliminary discussions that concern whether a rebuttable presumption that he should be detained arises. Okay, so we're going to learn about the presumptions that exist and really the burden of proof and who has that burden. So in other words, they're saying if the government comes out and says that the default position is that he should be detained, that creates a rebuttable presumption. So the defense can come back and say, all right, the law is saying we should presume to keep him in detention just based on the nature of the charges, based on the fact these were pipe bombs that could have exploded and killed somebody. So presuming all of that's true, we lock him up. But he can rebut that. He can provide other evidence to overcome that default position, which is what they're attempting to do now. So they write, the defense's position is that the government cannot continue to keep him in custody without a valid finding of probable cause. And they need to do that, the defense says, today at the hearing. The government is moving forward as though this is just a detention hearing, but they say, no, it's both. There's timing rules and requirements, and the defense is saying, we want our hearing today. Probable cause or not, even if you don't establish that today, the defense says Cole should be released. Why? Well, the Bail Reform Act, the laws, remember, we have a presumption of innocence in America, meaning you are presumed innocent. And so if you are presumed innocent, then the logic goes you shouldn't be held in custody if you can help it. Detention is a carefully limited exception. The goal is to let you out. The government-induced excitement around this arrest, which is a wild phrase here, the government-induced excitement around this, saying that they're running their mouths. He admitted everything. He told us everything during the interrogation, and really pounding this as though they got the guy, because really the DOJ needs a big win here. And this is a big win if they got the guy. So they're celebrating accordingly. Now, they give us some case law. They say, if there isn't any concrete prospective threat of public safety that can be mitigated, the default rule is to let you out. We have a presumption of innocence, so only if you have a real threat of harm, real concerns about public safety, real concerns about being a flight risk, like the guy's going to flee the country, then you got to let him out. Now, the question, of course, comes up is whether Mr. Cole is even guilty of these, but that is wholly irrelevant to this proceeding. This is a bail proceeding. You must assess the weight of the evidence, but not consider the defendant's guilt. Only consider the weight of the evidence of dangerousness, not whether he did the thing or not. It's only whether he's dangerous at this moment or not. Now, they give us a footnote, and they're upset about what the DOJ is doing. The defense says the U.S. attorney made numerous comments in contravention of local rules. The U.S. attorneys are talking about the defendant and trying to frame him as guilty, even though he's got a presumption. They say you can't do that, specifically about the existence of a confession. The rules say you can't talk about a confession if you're the prosecutor, but they did. ABC News has a whole article about this, saying you can't talk about the guilt or innocence. And Judge Pirro was telling the media that based on the evidence, she says it is, quote, unmistakable that Mr. Cole is guilty and that the guy was an equal opportunity bomber. All right. And that's her opinion. U.S. Attorney Pirro posted also on Facebook that he admitted that he was responsible for the devices and gave a detailed confession to the charged offenses. And so, of course, the defense rightfully is going to be saying, you're trying to presume an outcome that hasn't been proven in evidence yet, right? The case is not matured enough for you to make that conclusion, and so it's irresponsible. Now, the government's detention motion tells the court, we read this whole motion yesterday, it was very interesting, that the little more, in other words, there's nothing in there other than the fact that the government is optimistic, quote, that it will be able to convict Mr. Cole at trial. That's all they say. It focuses, quote, on the overwhelming evidence of guilt, the weight of the evidence against the defendant, the attendant likelihood of his conviction for the serious offense, all of that supports the pretrial detention. But they say the government is wrong. And again, if he made a valid confession, why is the defense fighting so hard? Is he retracting his confession? Wouldn't he, if he's of sound mind, just say, guys, I admitted everything, I did it, I'm dead to rights, there is overwhelming evidence plus my admission. Why would the defense be fighting so hard, right? Just give us a plea deal. Let's close this case out. But they're not. So has he retracted that confession? Mr. Cole is presumed innocent, of course, and any attempt to argue his guilt at this point in support of detention is misguided. And the burden on the government is far greater than merely reciting his criminal charges and concluding without more that he is dangerous. And this is one of the first things they teach you in law school. Like if you use these words a lot, oh, it's overwhelming. Oh, it's obvious. You can see clearly every time. Oh, you have to prove that. You can use those words. There's overwhelming evidence of guilt. What is it? You got to give the evidence. If you're just saying phrases without providing more evidence, then that's just fluffy talk that's filled with platitudes that nobody cares about. So they say the government is wrong. Now, the burden is greater than just dumping platitudes into emotion. The question is whether there is a present danger with this guy right now. A contention the government never actually makes. They don't talk about dangerousness. They just talk about guilt of dropping the bombs. Now, it's connected, obviously. If you're dropping pipe bombs off somewhere, there's an element of dangerousness to that. But it's their burden, they say, to demonstrate that he's a present danger right now. And they can't do that when you consider all of these other facts. He's just not dangerous. Here are the factors that apply to that analysis. We've got Cole's defense team saying, Mr. Cole is an African-American adult. He has been diagnosed with autism spectrum disorder, level 1, and he's got OCD, obsessive compulsive disorder as well, probably connected to the fact that he wiped his phone almost 1,000 times. They said he was hiding evidence, and it may have been that, or it may have just been he's got autism and he's OCD. Now, he's also got no criminal history, never had a problem complying with court orders, never failed to appear for a traffic ticket, never missed a court date for a domestic violence event. Mr. Cole is a high school graduate. He's had continual employment since his teenage years. He's lived in the same community since childhood, no incidents. His neighbors and others who've dealt with him over the years all vouch for his character. He has a reliable job waiting for him upon release. He can have a vetted custodian wherever he lives. He submits to house arrest. He'll put an ankle monitor on and have weekly reporting. He even submits to unannounced visits by pretrial services. No one in this case was actually harmed as a result of his conduct. No property was damaged as a result of the charged conduct, not necessarily his conduct, but what he's been charged with. Now, the government simply can't negate these facts, and so therefore the court should order his pretrial release, impose some strict conditions, but let him out. Here's why. The Eighth Amendment, it guarantees reasonable bail. Now, Congress created an entire statute for this, Bail Reform Act. It says you can only hold people in detention when no condition or combination of conditions will assure they come back, their appearance, or protect the safety of the community. So we have to lock them up because we've got no other option. But when ordering this detention based solely on the danger to the community prong, various prongs we analyze, the government needs to present clear and convincing evidence. The default position is you should be released because we have a presumption of innocence. Now, the Bail Reform Act, it does create a rebuttable presumption that no condition can secure the safety of the community if there is an enumerated crime, right? Certain crimes are just violent crimes, like dropping a bomb off is a terroristic type of a crime. So people can get hurt, so that would automatically create a presumption of dangerousness, but the defense can rebut that. But for purposes of making that determination, we do that through probable cause, by the way. And the court has made clear that we do need an independent finding of probable cause at some point. And the reasoning makes sense. He could still be brought to trial if he was indicted. He has not been indicted yet. Maybe that'll drop, maybe even today. But we need to have probable cause. And here, there is no indictment. And no pretrial detention can begin without that. And even if there were one, his burden of production is to overcome it is not heavy. So even if you say, yes, there's evidence that he committed this crime, the dangerousness is a separate analysis. He must proffer at least some evidence to show that he's not actually dangerous. And he can prove certain things, and he's doing that. Now, here's more. He should be released pending trial, writes the defense. No criminal history. There is zero evidence to think that he's going to flee. Each factor supports the release of these conditions and the safety of the community, and they're going to walk us through the various factors. You can see A, B, C, and D. We'll get here. First prong, first factor. What's the nature and circumstance surrounding this offense? We know, the pipe bombs. The government says we've got a violation of transporting an explosive in interstate commerce. We also have a malicious attempted damage by placing what they call the pipe bomb devices. Okay, they put it in quotes. And we've had the question about this, like FBI says they could explode, but what does that mean exactly? Devices placed outside the RNC and the DNC on the evening of J5. Now, according to the government, both devices were rendered safe, and they have weapons characteristics, but no device detonated, nobody was injured, no property was damaged at all. They're just kind of like, toys that are annoying just floating around DC. Now, the law directs the court to consider whether the offense is a crime of violence, which is what we're doing. Now, the government and their theory, yes, it involves an explosive device, but that alone is not enough. There are enumerated categories under the Bail Reform Act, and we have to ask ourselves about the risk profile. No actual harm occurred. The devices were rendered safe. No injuries, no property damage. And the charged conduct is also temporally remote. The placements occurred 4 years before he even got arrested, January 5th, 2021. And the affidavit doesn't say he was doing this again later. They said he went and bought more end caps and more pipe nipples, but not that he was making more bombs. So is he continually dropping bombs around? The government's proffer, if you just take it at face value, if you believe exactly what they say, it is retrospective. It goes 4 years ago, and it's circumstantial. It ties consumer purchases and sell records to a past route on a single evening. Those assertions go primarily to identity and to past conduct, and this is a merits question that the Bail Reform Act cautions courts not to resolve right now. We've got one issue. It's dangerousness. Is he dangerous? You don't get to go in and prove innocence or guilt at this status, which is what the DOJ is asking you to do, says the defense. Now, finally, the unique conditions also surrounding J5 and J6 are unlikely to recur. We're not going to have another election that creates the same environment that we had back then. The court must then ask, can we mitigate any leftover residual risk? Let's put them on GPS monitoring. Let's put them on third-party supervision. We know the riots were dangerous, but here, in this case, there was no detonation. There was no injury. There was no damage. There was a 4-year gap. There's no proffer from the DOJ that it's ongoing danger or an ongoing threat. So none of those meet the factors that are required under the law. Now, the weight of the evidence, by the way, if you just measure what the government is arguing, it doesn't meet the threshold. A prior court case called Hunt warned against assessing the weight of the evidence in terms of guilt. This whole analysis is about dangerousness, not about guilt. So the DOJ coming out and saying overwhelming guilt is not the analysis. They say that's wrong. Here, the court examined a pattern of unlawful behavior in the other case, and this is how the factor works. You can evaluate unlawful, dangerous conduct to determine whether that will contribute to future conduct. But that hasn't happened here. Everything in this case is retrospective, looking backwards. It's all circumstantial. And even if you take whatever the government says at face value and believe it unequivocally, their evidence only describes one isolated window on a single evening nearly 4 years ago. There's no pattern of troubling activity. No devices exploded. The government has not alleged anything similar going on. It's all circumstantial. No ongoing threats, no ongoing harm of dangerousness. But instead, on the opposite factor, the history of this guy show that he is unequivocally entitled to conditional bail. They say in other cases, in this case called Klein, the courts would analyze a bunch of different factors and say, well, maybe the DOJ says he is harmful and dangerous, but everything else shows that he's not. The available information about his character is now submitted. We'll read through some of the letters. But he's also got family ties, employment, financial resources, been in the community for a long time, has ties to the community. We've got no concerns about appearing at court proceedings, no past drug or alcohol abuse, no criminal history, and he was not on parole or anything like that during this case. Same thing here. Let's just apply those factors. We've got Brian Cole Jr. comes from a close-knit family who had no idea he was doing any of this, like can't even believe it. He attended a local college. This was in Klein. No history of drug, minimal criminal history, maintained steady employment. They went through in Klein, and they also noted also unfavorable factors. So Klein sounds like a Proud Boy. He was at Proud Boy events, and he was at least prepared to engage in violent conduct. But in this case, Cole is similar, but it's also very different. Okay, so in this case, it happened this way. Ours is kind of similar, but different. Here's why. In this case, Mr. Cole is a high school graduate, has been working with his family since age 14. Strong family ties to the community, raised in Woodbridge, Virginia, lived in the community for the past 21 years. His community ties are further exemplified by the strong character references that we'll read in a minute. He also, if you let him out, He can continue to be a productive member of society. He's got a job waiting for him, works with his family at the bail bond business, high school graduate, supports bonded individuals to actually comply with the courts. Like, Judge, look, he's helping you. His position remains available to him. And so if you let him out, he can go right back in with his family. He'll have a job. There won't be any additional problems coming from him. Now, similarly, he's got no criminal history, never been convicted or erected, no history of failures to appear, was not on probation or parole. There are classic markers of reliability. None of this supports detention. Nobody's even disputing these things. There's no pattern of alarming conduct, and he is not a danger to the community. Now, relevantly, the government, the prosecutors came out. They failed to mention even the vast majority of factors that we just ran through. They don't want to talk about those things because they know it's not going to work out for them, choosing simply to focus on cursory, unsupported allegations. For example, the government argues that Mr. Cole spent nearly 5 years trying to evade detection. They say, what? That's not true. Mr. Cole lived with his parents the entire time. He never moved. He followed the same routine daily. Avoiding the litany of factors that favor him only shows that they don't want to talk about it because they know that they're weak against them. The government also, says the defense, fails to cite even one case in its entire argument section. And this is what prosecutors do all the time. You can say there's a concept called emotive conjugation. So, you can conjugate sentences, conjugate words to mean different things. Like, I run every morning. I ran yesterday. Okay, tenses and conjugating the phrase, the language. Same thing can happen with prosecutors and charges. They say, oh, he fled the scene. You say he fled the scene? What? He went home. They're both describing the same action. One person in one location leaves that location and goes to a different location. Cops will come up and say, why'd you flee the scene? You say, I didn't flee the scene. I went home because I was, late at night. That's why I went home. So you can use language to describe the same conduct, but they have very different meanings. So that's what they're saying is happening here. Government said he avoided detection for 5 years. He wasn't like living in a bunker somewhere, running around like Ghislaine Maxwell, living in mansions, trying to, escape any accountability. This is very different. He was at home with his folks. FBI's like, we can't find him. In sum, nothing in the record suggests anything evasive at all. He was living at home, or resistance to law enforcement. Now, the government does not allege that he attempted to flee, never did. They don't say he attempted to obstruct, never did. He deleted his phone almost 1,000 times because he's got OCD probably, or that he tried to commit additional crimes. Simply, he doesn't pose a danger to the community. Now, the government bears the burden of proof here. They need to present clear and convincing evidence that we can't have a safe community if this guy is let out. But they can mitigate any risks, and the government has not carried their burden. No evidence that he's a clear threat. All we have in the conduct is a single discrete episode on January 5th. It's a pretty big episode. Now, the court must examine whether the circumstances that made it possible create danger and can possibly harm the community. Now, the circumstances around this extremely unlikely to manifest itself again. Probably not going to have another stolen election by the CIA and Team Biden. And even if they were, we can neutralize this risk. The government has not identified any present-day factors. There's no access to weapons. He's not procuring additional weapons. No recent extremist posting. No organizing conduct. Nothing that would make him dangerous because it doesn't exist. Whatever risk the government says is just theoretical. It's backward-looking, and it's belied by the past 4 years where he lived at home and he didn't blow anything up. So all of this weighs heavily against the inference that he's a danger. Now, in any event, stringent conditions, if you do release him, will solve all of it. Put him on home detention. Put an ankle monitor and GPS monitoring on him. Have a third-party custodian supervise him. Have his grandma come over. She lives in Gainesville, Virginia. He'll surrender a passport. He'll restrict travel to this district. He'll submit to pretrial oversight with in-person reporting. He'll abide by a no weapons order. He'll remove any firearms. Everything you want, just let him out. So to specifically address the government's theory if you're saying, oh, he's going to blow something else up, he will agree no explosive materials, no components referenced in the criminal complaint, no pipes, no end caps, no black powders, no commercial igniters, nothing. Without written approval, he's not going to even contact anybody outside the presence of our counsel, won't post on social media, won't engage in any conduct, will maintain verified employment, everything. He's going to do it all. Now, courts in this district have recognized that these types of conditions can mitigate any risk of harm. We've done it before. Let's do it again. Now, this guy, a J6 rioter, was even released. And he sat in Mike Pence's chair. So if he can be released, you can release our guy. Now here, a years-long gap free of similar conduct of anything matters. And the government has not shown, much less by clear and convincing evidence, that the only way we can protect the community is by detaining this guy. And so, therefore, order his release. Let him out and do it soon, is what his defense team is saying. Mario B. Williams and John Shorman, basically, today we're scheduled for a detention hearing, so that's their final argument, making its way into the judge's chambers. Now, we also had some character letters that came in. We're waiting for the judge to respond. Is this going to be a full-blown preliminary hearing? Is this going to just be a detention hearing? We'll find out this afternoon. But we also have character references that were submitted on behalf of Brian Cole Jr. You see, they write here, December 12th, from somebody anonymously out of Fairfax, Virginia. They say, all right, this letter is being presented in reference to the character of Brian Cole Jr., the alleged pipe bomber. I am currently the property manager for the building here. Now, the Cole family has been one of my tenants for 22 years. During this time, my experience with the family has been nothing but positive. They have always paid their rent on time, been respectful of the property, been great neighbors to other tenants. And since Brian Cole Jr. has been coming into the Fairfax office, he keeps to himself, has not caused any disruption. From what I've seen, his daily routine is to monitor the front desk in Suite 101. He makes trips to the bank, and he does other administrative tasks for the businesses. While completing these tasks, I have not seen or heard anything from Brian Cole Jr. that would be considered violent, disruptive, or concerning. I've only known him to be quiet, respectful, and kind. While I understand the seriousness of the charges, they seem totally out of character from the Brian Cole Jr. that I've observed for many years. If I can be of further assistance, please do not hesitate to contact me. Sincerely, this dude over here. Another one came in from this person saying, yeah, I'm writing this letter to give you some insight into Brian Cole Jr., or the young man that I know him to be. I was hired by his father in May 2003 to work at a bail bonds company, and during this time, I observed Brian Cole Jr. going from a young boy to a young man who never showed anger or frustration. He has always been very polite and respectful, always showed kindness to the other employees or clients coming into the office. Brian Jr. has always been a calm person who loved computers. Even though I moved from that area in 2006, I have had the pleasure of dealing with Brian Jr. when he answers the phone at the office. I know I can only give a limited amount of information, but I do know that the charges against him does not fit the character of the young man that I know. Signed sincerely by RLS. Another one, December 6th. And this is good defense attorney work. This is called Mitigation, and they're going through this process. They started it immediately right after he got arrested, sending letters out to all family. Write a character reference letter. I am writing this letter to provide insight into the character of Brian Cole Jr., whom I've known from over 10 years as a business associate of his father at private security and other programs. During this time I have known him, I have had the opportunity to observe his personal and professional behavior. One of the most admirable qualities that stands out was his peaceful nature. Over the years of my interactions with him, I have never seen him emotionally angry, upset, or even frustrated. His demeanor has always been calm, collected, respectful, simply kind to others. He was at work every day I had the occasion to go into the office. He was always committed to doing his work and manning the front desk. Now, I understand the seriousness of the situation that he's facing and do not wish to undermine the legal process. However, the limited information I possess and the alleged actions leading to his involvement in the case are not reflective of his true character. I have only witnessed him as a decent and well-mannered young man in all my encounters and interactions with him. Should you require any further information, please give me a call and let me know. Another one from this person. I also support Brian Cole and give my knowledge of his character. I've known them for 25 years. Whenever interacting with Brian, always quiet, calm, respectful, never angry, never emotional, never missed a day of work. The public portrayal of his involvement saddens me greatly, as it does not reflect the character of the young man I had the privilege of knowing these many years. If I can help anymore, let me know. And then the last one came in from this guy, E.D. Jr. I'm writing this letter on behalf of my step-grandson. I've known him all his life. I've had the privilege of watching him grow into a responsible, caring, and hardworking individual. He consistently demonstrates qualities such as integrity, kindness, and respect for others, great dedication to his work, his dog, his family responsibilities. I've never seen him angry or disrespectful to anyone. My interactions with Brian have always been positive and very polite. He was always at work doing his job diligently and never bothering anyone. In addition to his strong moral character, he's dependable and trustworthy. I have no doubt that he will continue to make positive contributions to his community and uphold the values that define good character. Please call me if you need anything else. And so these are helpful. They're not dispositive, right? You can't really say, well, you could all have been mistaken. You could have still done something bad. We all know many good people who are people of integrity, honest. Many of us are honest and hopefully have integrity. And we still have done bad things in our life that are out of character, right? So one thing, being out of character doesn't mean it's impossible to have done that. But the people closest to him are saying, we don't recognize what the DOJ is saying about him. We've known him for decades, and this doesn't match the same person. So, of course, we've got a hearing today, which we are going to be attending in person. And then when that is over, we'll do a debrief and detail exactly what went down inside, and we'll come back and we'll have an update. But still nothing from the judge on whether we're going to have a detention hearing alone or a preliminary hearing and a detention hearing. And so the prosecutors probably getting geared up for both in the event that happens. But level 1 autism that they say this guy has shows, according to autismspeaks.org, that this is where he is on the spectrum. Without supports in place, without family, he's going to have communication problems, noticeable impairments when communicating with people. So if he's being interviewed with prosecutors and FBI agents without lawyers, without support, he's going to have noticeable impairments if he's a level 1 autistic person. Nobody was there with him, so that's going to be a problem. He also has difficulty initiating social interactions, atypical or unsuccessful response to social overtures of others, and may appear to have decreased interest in social interactions. So when he's being bombarded in the middle of an interrogation for 4 hours, maybe he breaks down and says, yes, I did it. Yes, I did it. Inflexibility of behaviors causes significant interference with functioning, difficulty switching between activities, and problems of organization and planning hamper his independence. Wild. So he's got all of these things going on, but he was still able to build 2 pipe bombs, drop them off at 2 major buildings, the RNC and the DNC, and then be so forensically sealed up that you can't see even the color of his skin as he's walking around. You've got eyeglasses on, a hoodie, a face mask, gloves on, can't see anything, but he's, meanwhile, parks, walks around basically Capitol Hill, DC, and then drops 2 pipe bombs off, goes back to his car, picks up the other pipe bomb, drops it all off in about an hour, and then leaves, doesn't leave any DNA evidence or any other forensic evidence that will catch this guy for 5 years. Then they suddenly capture him years later, and boom, they got him dead to rights, and he confesses everything. Very interesting. Now, higher level of autism, level 2 and level 3, require more support. In this case, a level 3 autistic person, for example, very limited interactions, minimal response, severe deficits in verbal and nonverbal social communication skills. So level 3 would be at the highest end, but level 1 is at the lowest end. But still, it's, according to his defense team, something that they have validated. He's actually been diagnosed with level 1 autism and with OCD, which I think explains a lot of the behavior that we saw during the interview, and even in their motion for detention saying that he was wiping his phone almost 1,000 times. It seems like maybe that OCD behavior can explain some of that. So this is going to be a very interesting hearing. Of course, we're going to be there in the courtroom, and then we'll have an update after the proceeding takes place to ask ourselves, is Brian Cole Jr. the real pipe bomber? How does his movements match the video surveillance that we saw released by the FBI? So we're going to attend there. Then we'll be back with more. Thank you for subscribing and joining as we keep our eye on this one. All right, my beautiful friends. Yeah, that's going to be an interesting case to watch. All right, now let's talk about some follow-up to yesterday, because we now have new documents released in this case. The secret closed-door session transcript has now been released. We're talking about the Tyler Robinson case. Of course, the alleged assassin against Charlie Kirk had a court proceeding back in October that we didn't know about. Nobody knew about it. The media found out about it, was furious that this happened in secret behind closed doors, and we had a big battle over whether or not we, the people, the public, would get to see inside and learn what happened. But now the judge has dropped this, a 97-page transcript with some nice redactions in here that we'll go through and see what actually went down on that day. And a lot of it is interesting, but a lot of it is stuff that we've already talked about. And so some of the redactions seem a little bit unnecessary, but we'll go through it and see what you think about it. But Fox News got their hands on the transcripts and they share it with us. And the redactions were not that much, only 246 words in the 80-page transcript were ultimately cut out, even though the whole hearing was cut out. And the audio has not been provided to us, but that should be coming out in a few weeks once they're able to go into the audio and clip out the redacted portions. So we've got some more transparency here, and this, of course, is Tyler Robinson, the man who allegedly shot and killed Charlie Kirk. Here's the judge, Tony Graff, and we've covered the proceedings here from the very beginning, and we missed this one because they didn't make it available to us, and we were very upset when we saw it hit the docket. We said, wait a minute, what? And we could feel that there was a secret hearing because stuff was happening that they didn't tell us about. But now we've got the documents unsealed with slight redactions, asterisk. And so here's what went down. October 24th, 2025, 4th District Court, Provo, Utah. Case, State of Utah versus Tyler James Robinson, the alleged Charlie Kirk assassin. We see the court reporter. We love our court reporters. It's called Phoebe. Good to see you, Phoebe, in the house. Shout out to our court reporters. Court is now in session. Judge bursts through the door. All rise. All right, here comes the judge. All right, please be seated. Court is now in session. We're calling case 2514-03576, State of Utah versus Tyler James Robinson. Counsel, would you please enter your appearances? Good morning, Your Honor. Christopher Ballard on behalf of the state government prosecutor. Also here with me is Jeff Gray. We've got Chad. David's here. What's up? Ryan's over there. Lauren's here. We've also got Beth Van Noy from the county attorney's office. He's going to be representing the sheriffs today. All right. Thank you. Good afternoon to you all, says the judge to the prosecution table. Now looks over to the defense. Defense stands up. Miss Nestor. Good afternoon, Your Honor. Kathy Nestor, Richard Novak, Stacy Visser, here on behalf of Mr. Robinson, who's now seated to my left. Thank you. Good afternoon. Mr. Robinson, says the judge. Good afternoon to you as well. All right, counsel, says the judge. We have a few matters to deal with. Now, I appreciate you making yourselves available. I wanted to have a hearing so that we could vet all of this out, and we'll have some further rulings later. So, attorneys, how would you like to proceed? There are, for the defense, maybe we'll start with you. You filed the original motion, Tyler Robinson defense, and so I want to make sure that we pick a path that is organized and easy to follow. What do you think, defense? Well, thank you, Your Honor. This is Richard Novak here. Yeah, there are certainly some sort of related, partially briefed issues. We want to talk about shackling first and the handcuffs. First thing we did want to ask the court to do is have Tyler Robinson in this hearing make one of his hands available. Okay, he's shackled up. Unlock one hand so we can give him some pen and paper and he can write notes. I don't see why he can't take notes during this hearing. No one's going to be harmed. And so we should unshackle him. Redacted, redacted, redacted. Something about him writing, and he's not able to write or take notes during what could be an extended hearing, and we'd like to have him be able to do so. So they might also be just describing what he is in right now. Currently, his hands are tied together. He can't extend his hands to put both hands up to write. So they're describing the security posture. So they cut that out so we don't know it. So then we'd like him to be able to do that. Redacted, redacted, redacted. It's a sealed hearing. The public's not here. So we just can't imagine any specific reason why he can't have his hands free. Just take his handcuffs off. Judge says, all right. How about you, prosecutors? You want to be heard on this? Yes, we do, Your Honor. This is Ben Van Noy. I'm from Utah. Now, given the substance of this motion, I'm objecting on behalf of the sheriffs, okay? This is the heart of what we're trying to decide here. This is a pretrial proceeding. Yes, redacted, 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 but we request that that be denied, okay? It should be in all pretrial hearings. Keep his hands locked up. All right, any further input from the defense or from the government? No, Your Honor. All right, the judge says. Is there a way to unshackle one hand for him to be able to write that doesn't compromise the rest of? The bailiff says, redacted, redacted, redacted. Probably saying, yeah, we can unshackle one hand. We'll tie the other hand to the chair or to the desk. Something is an alternative procedure. He says, all right, yeah, let's go ahead and do that. All right, and while we're waiting, Your Honor, I don't care if this is on the record, says Mr. Novak. I have a really bad sore throat. So if I put something in my mouth, it's not gum, okay? And it's not candy, okay? But if anybody wants a Ricola, then I'm happy to share them. Judge says, all right, thank you. Court says, well, it depends on the flavor, says the judge. He says, oh, it's original. He says, okay, all right, those are good. Some of them are nasty. He says, no, I don't like any of that stuff. There's a pause in the proceedings. They're all slamming back Ricolas. Man, these are good. So the court says, all right, it's pretty good. All right, I'm good now. So before we begin, I just want to make sure that we're all on the same page. Now, Mr. Novak, can you touch on the topics that you want to get into? He says, yeah, sure. I'll do a little bit of a roadmap here, and I'll tell you what I want to get into. So the defense, on Mr. Robinson's behalf, we want him to appear in civilian clothing. And that's something we want to talk about, too. The state hasn't responded at the time. We also filed a motion to strike the state's opposition. There's a whole section in here about whether the sheriffs can be a party to the case. Remember, the sheriffs kind of submitted a filing in the case objecting to certain things. The defense said, you're not a party to this case, sheriff's office. So you can't be a part of it. And the judge said that was right. Basically, they can make their opinions heard, but they're not a party to the case. So it was just a procedural kind of little hang up. Now, some of the motions are related, but I think we've got a roadmap here. A couple things we want to get into today, Judge. First, civilian clothing. We want restraints to be talked about. We want to eliminate all video and audio broadcasting or delayed feeds. The defense wants the public cut out completely. We haven't briefed it, but we're going to come back on that. And we're also going to bring other motions. Now, the court came out with a pretrial publicity order, and we're going to be asking to modify that as well. And we've covered a lot of this, so the stuff we've already covered, we're going to fast forward through. There are two other reasons why shackling, we believe, is unconstitutional, and you can't have him shackled in these proceedings. We've also submitted another motion to disqualify the Utah County Attorney's Office. We read that motion because one Utah County attorney had a kid, apparently, who was there. The court says, okay, so you want us to talk about that? We're in a sealed hearing, right? Maybe we can talk about that since it's sealed. He says, yeah, go ahead, talk about it. Defense says, okay. And look, I'm not trying to pre-argue these issues, says the judge. But since this is a sealed hearing, the defense, let me explain it to you, Judge. But Utah, the prosecutors, they've advised us that a family member of one of the attorneys was present at the incident where Charlie Kirk was shot and killed. That this child, I don't know if they're an adult or not, but I'm not referring to them as a minor. It was a child of a prosecutor. So this child was present. They observed it. They were 85 feet within the distance where Mr. Kirk was killed. They fled. Now, Utah was advised of all of this. Law enforcement was actually deployed to the area With her safety in mind. Uh-oh. Yeah, so now we know it's a female. They redacted all the pronouns in the last motion, so now we know it's a female child. I am not trying to pre-argue this, Your Honor. I'm not saying anything that we haven't already discussed a couple of times with them. So we are going to file a motion to disqualify them all. We read through the full motion previously here. And all of these motions, we've already talked about getting them all filed before Thanksgiving. Now, that doesn't mean that we want the court or anybody else to work over the holidays, but there's a lot of work here, so we need, a few weeks to get it all done. Now, you might have a preference about how we handle these motions, so you let us know, and I think I should stop talking here. He's like, all right, that's good. All right. Judge says, and to the state, I just want to make sure that from your perspective, you agree with that? I don't want to go down the path and then somebody says, well, wait a second, we weren't supposed to be talking about that. We need to have a starting point, right? Prosecution says, yeah, that's perfect. Yeah, let's do it. That sounds like a good roadmap. We agree. We should start with the motion about the sheriffs and explaining what they filed and why they filed it. We'll respond as soon as they file. We'll respond quickly. Now, there are two other things I think you should be aware of. The defense wanted to preserve evidence. We think that's premature. And the state filed a motion to set that aside, and so we'll also want to discuss that too. Now, Tyler Robinson's response to that motion is due in November. Then we'll file a reply. We'll meet and confer. Obviously, we're going to preserve evidence. And the real question is, what needs to be preserved and what advance notice needs to be given before the biological evidence can even be used, even if it might disappear? Okay, so DNA evidence, what did they find from Tyler Robinson on the gun or elsewhere? And so we're going to try to at least meet and confer about that, but we'll have different definitions of materiality, and we may have to fight about that later. Okay, anything else? Nope, thank you. All right, judge says, okay, good, fine. All the preliminary stuff out of the way. The one concern that I have, though, and I appreciate counsel laying this out, is the issue of the media and photographs and video, because this is very ripe. We have a hearing on the 30th, the judge says. And so I'm just trying to get an idea of how much time do we need? This is all intertwined. So where are the parties at with that? We're going to have a hearing coming up. They say, well, actually, we don't even know if we need a hearing on the 30th. Okay. And we talked about that with Mr. Robinson. He understands the consequences of further delays in the case. I don't want to speak for the prosecutors, but I don't think we need a hearing. I think we can have a hearing in early January. We're going to get all our briefing done, and we can come back on that. Like, we're not going to get anything done before the 30th, so I don't think, we don't need that hearing. Okay, so if the court's comfortable with vacating the 30th or postponing it, that's fine with us. Everybody's happy postponing it. All right, judge says we'll address that later. Now, I want to talk, the judge says, about the motion to strike to get rid of the sheriff's office as a party to the case and dress and restraints. All right, now Mr. Nestor is going to handle this. Mr. Novak says, I'm going to sit down. Miss Nestor stands up. All right, good morning, Your Honor. This is Kathy here. Now, may it please the court. We're talking about procedure and what needs to happen here. Now, I think we're all working really hard to get this thing quickly solved, and I appreciate you working with us on this, Judge. Now, we've already laid the groundwork for a lot of this, and she says we're hopefully, this is interesting, because we are looking at a very long case. This is the defense. This case is probably going to last a long time. She says, hopefully. Yeah. Delay, delay, delay. And we're very concerned about right from the get-go a precedent being set where the sheriff can come in, lodge objections, and more. We've cited these cases. The sheriff's issue we've discussed. The sheriff is not going to be allowed to be a party. It's not that interesting of an issue. The judge spends a lot of time on it just saying, well, how can we get their opinions heard? And the prosecutors say, they can submit letters and things and they can communicate their position, but they don't actually have to be a party. So affidavits and more, and we just don't want them to be a party. Okay, so you're saying the state should be allowed to call them as a witness, right? But not a party. Yeah, sure. So they can put on evidence and they can have evidentiary hearings and all those things, right? She says, yeah, exactly. So that's what we want to do. And the sheriff can make their positions heard. And the court says, okay, so your argument is the sheriff is not a party. Is that right? Like they're not actually a party, but they can't file objections and things like that, right? Defense says, exactly. Yeah, right. The motion says the sheriff objects to. Okay, the sheriff is not a party. So the prosecutor can object on behalf of the sheriff, and it's a pretty simple issue. Then it goes to the prosecutors. They say the sheriff can file whatever they want. It's a joint response. You ordered the sheriff to respond, and so they responded. The state was simply trying to comply with your order. Like you said, the sheriff should be responding to this. They did. That's all. We weren't trying to do anything strange. The court says, oh, okay. Well, let me clarify. Here's what happened. That was a holiday. The court came out, issued an order. So I was like talking colloquially, like I need your position on this, but I understand the confusion. The judge says, okay, this is what I ordered, and I didn't really mean it that way. So let me clarify this. And the court says, okay, moving forward, we can just treat them as witnesses. Does that work for everybody? Yeah, okay, absolutely. The sheriff wants to make it clear they're not entering an appearance. So even the sheriff's like, no, we didn't even want to become a party. So a lot of confusion. They get through it. Any other questions? No. Anything further on this? One more thing, Your Honor. All right, we got it. One more thing. All right. Anything else? And Miss Nestor says, let me talk to someone smarter than myself. I love that line. Let me ask Miss Visser really quick. Ask the co-counsel. And then sometimes the sheriff could enter an appearance, but most of the time not. So they should just go through the prosecutor. All right. Anything else? No. Great. Sheriff's issue is now over and done. We just burned 29 pages on that issue. Great. Now we get to some better things. All right. Now, the judge, with that, we're done. Let's now talk about his appearance in court and the restraints. Sheriff can lodge objections through the prosecution's office, and that's the end of that. All right, defense. Thank you, Your Honor. Now, after these introductory remarks, we did want to take the weekend and think through some things. We've done that. Now, as always, we should start with the Constitution. And I know you read our briefing. We brought up this case called the Deck case. And the Deck case said if you have a blanket policy of shackling people, that's a problem. There was another case called the Cravens case. And it's about you need an individualized determination for the defendant. Should we shackle this defendant or not? So I will address why I believe that we should not have him shackled. The first is there's a presumption of innocence. And how does it look if our client is sitting there shackled? And the third reason is that we need dignity and decorum in the courtroom. What do you think's going to happen when the cameras see him come in here in shackles? It offends the dignity and the decorum of the courtroom. And this is not a jail, judge. This is your honor's courtroom. This is your courtroom, judge. And what security measures are in place to ensure safety? They're already happening here. So we don't need hypotheticals. Tyler Robinson's not going to burst up, just start murdering everybody in the courtroom. So you need an individualized determination that he needs to be shackled in a courtroom, redacted. We're not asking that law enforcement officers not be present. We're not asking you to eliminate security concerns. Just why does he need to be shackled? Here's another one. When Mr. Robinson first was arrested, something redacted. And I think it's interesting that the Sheriff's Department hasn't provided the court with any information about why that is, that he has convinced the Sheriff's Department that that's not necessary. So he wasn't shackled, or I think we saw him in a suicide vest, but he wasn't placed on some status or considered to be a high risk for whatever reason. So now it's interesting that the sheriff wants to keep him shackled. Now Mr. Robinson has, as I understand it, is under a state law. He's got a right to privacy with his medical records and more. And the sheriff has an obligation to make an individualized determination. So basically, you haven't done that. You just have a blanket policy. You needed to analyze him individually, so we want you to do that. We were here a few weeks ago. The Sheriff's Department took the first appearance very seriously. We appreciate that. Something, redacted. That's not Mr. Robinson. So I don't think that the intense public interest, which may be drawing in unstable fringe people, who the heck are they talking about? From the left and the right and other places, is imputed to him. Can the court trust him to sit there and not murder anybody? The answer is obviously yes. So then I want to get to a slightly more open question. Does this constitutional right attach throughout the entirety of the case? And we've briefed this, more holdings. Sanchez Gomez is another case, 4 defendants in that case. And the Ninth Circuit also said this. Then it went to the Supreme Court. They said it was moot. They said they're not even in court, so they're not being shackled anymore. Case is over. But he said, I reviewed this again, and I've done some very deep analysis on this. So what we're asking this court to conclude is that there is nothing in Utah law that compels a decision either way. You should follow the U.S. Constitution. We think here that an individualized risk assessment of Tyler Robinson would be warranted. And while we understand that there's a lot of what I call noise, there's noise on the outside. Redacted, 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 redacted. Maybe not. I saw one person with a camera in the lobby today, and I don't know, we also got here at 2 o'clock, so maybe there was more, or maybe nobody was interested. It was going to be a sealed hearing. Nobody knew about it. He's like, well, nobody was there. Nobody knew about your secret hearing, but none of that affects Mr. Robinson's rights to be free from shackling. If we do have an evidentiary hearing about this with an individualized showing, I think you should do that, and then you can make a decision. But as long as the court permits cameras, whether it's video or still cameras, to broadcast either live or with delay, we also believe that he should be dressed roughly like everyone else around him. The sheriff's department released a booking photo, and because there were cameras in the first remote appearance, we've already seen him with a jail jumpsuit with the vest on. We saw that. Yeah, like a suicide vest. Now, the suicide vest, Mr. Robinson, redacted, 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 was never suicidal or didn't need that, but the sheriff put it on anyways, and he's since been validated to be not suicidal. We get it. But if he's going to be in this courtroom, and we're going to have a secure courtroom, and he's going to be broadcast to the world, he should be depicted as a citizen, not as a jail inmate. He has the presumption of innocence. We want street clothes. We don't need shoelaces. If we can't have a tie, we'll get him a sweater. But unless we're going to shut down all video in here, he should not be in his jail outfit. So I think that is where we'll leave it, Judge. I don't think there's anything more. Thank you, Your Honor, for considering it. So that's from the defense. Unshackle him, put him in civilian clothing, or ban all the cameras. All right, prosecutors, what do you think? Well, Your Honor, I think this issue raises 2 things. First one is this. When is his presence necessary at a hearing? And then the second one is, when his presence is necessary, what measures are necessary because he is here? And I think, of course, the overarching question involved in the motion is how do we protect his presumption of innocence? How do we avoid tainting the jury pool? And let me make it clear, we're just as concerned about a fair trial in this case as the defense is. So we are going to try this case once. Now, as far as the first question, whether his presence is necessary, I think this court can resolve many of those issues by holding non-critical hearings either virtually or hybrid when he can appear from the jail. We can, I don't know what this redaction is, like turn the cameras off, and this court has discretion as to what format this hearing will take. And I was irritated about this at the beginning. Why are they making everything virtual? So they can all just call in? It's a pretty important case. Maybe put on your pants and go into court. But Rule 17, they say, we could just have virtual hearings. And he can be there. We can just turn the camera off. And he can talk to his lawyers digitally. I think the court could just do that. We could avoid a lot of these problems. If we have virtual hearings, we don't even have to talk about shackling. It also avoids significant costs and risks, including transporting him here to court. It's like every other criminal defendant in America charged with felony and murder, you get transported to court for your felonies, but this guy gets a benefit of just sitting in jail. Being transported is a lot of work. They hate it. It sucks. You have to get up like 3 a.m, get over there, get transported, then you sit around forever while the bus comes and it takes you, you're sitting around waiting. They absolutely hate it because it sucks. I think it's interesting that in one of the cases that they cite, it's called Luthi. There's another subsequent case here, and there's a battle over the case law. So again, I think the first issue is, do we even need him here? And once he is here, then what do we do? So many of these opinions they're citing are just terrible. It's vacated. It's like it didn't even exist. Why are they citing it? Now, they say they've also looked at the Supreme Court cases, and that's also unremarkable. And the sheriff can do what he needs to do under our rules. And he says that if he's shackled, he can't talk to his lawyers. But that doesn't make any sense. Of course he can. Just use your mouth. His mouth's not shackled. I think any suggestion that this court might be prejudiced by seeing him in jail clothing is because he's in custody. These are all normal, would have the same effect on a judge as it would on a jury. And the other cases that they're citing are in different phases. So all in all, there's dissenting opinions in those prior cases, and they talk about various rationales, talks about the Ninth Circuit case, fast forwarding through the case law analysis. So I think it's important for this court to ask what the security administrator wants to do as well. There is significant publicity in this case. And again, where Tyler Robinson has suggested that he would be okay with not having any photographs at all, these images won't be broadcast to the potential jury pool. The booking photo did come from the sheriff, but it was not the sheriff's office that released it. That was a different law enforcement agency that released it, so don't blame the sheriffs. So that's what we have to say, Judge. Any questions? Yeah, I do. Court, what prejudice is there if he appears in civilian clothing? Like, how is that going to hurt your case? Well, I think it goes to security. It's harder to identify him if he's in civilian clothing, like if a judge escapes him out her back door. So the judge says, is he going to escape? He says, looking at this courtroom today, if he was in civilian clothing, is this a realistic threat? Like he's going to just up and leave? Well, I'm asking you. He says, let me have my colleague answer that, another prosecutor. He says, no, I want you to answer it. I'm trying to understand your thinking. You just said that he could be a security risk. Is this how? It's clothing. I understand the rationale. I'm just trying to ask how it would work here. Is there a threat to security? Well, we're talking, in this case, no, but we're talking about public hearings as well. And what about jail clothing? What if he's in jail clothing? Isn't that also a risk? And talking about identifying jurors and more. But even if I were, the judge says, to go down that route and say no one can comment on his clothing, what if it's a member of a blogger or something? Well, we have general concerns about how he is dressed. Some people say it's undignified, redacted. And I think going to the suggestion and I think agreement that no video or photographic reporting could happen. All right, any more questions? Judge says, I got to think through all this. It's taking a little bit for my brain to go through all this. I'm still thinking. Judge is sitting there going, this is a lot of nonsense. I just don't want to interfere. No, and I appreciate it. I'm happy to answer your Honor's questions. He's sitting there thinking. All right, I'm still trying to take detailed notes. All right, Judge says, going back to the clothing. What if we order no videos, no cameras, and says you cannot write about the clothing? Would that work? Would that solve this? Does this prejudice the jury pool? No, I don't think that does, Your Honor. Every case that comes to trial, everybody comes in jail clothing and restraints. I don't know why this situation is anything different than the other cases here. All right. Talking more about shackles, and let's see what the judge does with it. All right, I appreciate the candor. Now, the second question I have is about the individualized approach. And we're fast forwarding through some of this. We know about the court's question. He surrendered. A neighbor of his, I'm sure the court has read enough of the materials. I think it's even in the probable cause statement. You don't even have to read the public accounting. A neighbor of his was a retired sheriff from Washington. He got in that man's car. They took him to the sheriff's office with his parents in the vehicle with him. So what information does the court have to say that if somebody is testifying in a preliminary hearing, said something that he felt uncomfortable with, and they're just talking about all sorts of stuff. 14th Amendment has a right to be present, but we can have these things virtually. More jail clothing stuff. And I do want to say something about presumptions. I think the last thing I want to say, this is a very serious offense. Anything further from either side. I want to talk about the media, says the judge. Lots of talking kind of in circles is what all this reads like. Now, I also don't think if this court were to eliminate cameras, which hasn't been fully briefed, I don't think that goes to the shackling issue. They're different. We have to balance the defendant's rights and about his right to be present. State is saying we don't need him here for some of the non-mandatory proceedings. Now, even if he were here in civilian clothing, redacted. Again, more talking in circles about the rules. And because we're in a sealed proceeding, says the judge, we're addressing restraints and constitutional rights. I'm going to come to an agreement by Monday. We're going to have a WebEx hearing. The judge is going to think about all this. We're in agreement on the striking the 30th date. So we're not going to have the 30th date. Let's pull up a new date. Judge says I need to think about all these things. Any updates on discovery? Yes, our office, the prosecution, has delivered 4,000 files from law enforcement. We've got 1,700 files within the last 12 hours. There's a process we're going through. We've given the defense 1,442 files to the defense. There have been a couple of hiccups because of our filing system. There's a lot of surveillance camera there. We are starting with September 10th being the most probative, the most important day. We're working backwards from there, working out a few kinks. Okay, anything else? No, this seems accurate. We are getting that material. The judge says good cooperation is important. There's no discovery disputes thus far. Judge talking about the preliminary hearing. One more issue. How long is the preliminary hearing going to be in January? Defense is going to cooperate. Any other potential dates in January? Assuming the court has a clear day. This guy has a large homicide trial coming up there. So they're just figuring out dates. Judge says, what about my dates? Judge says, you're booked. You're booked with jury trials every week. Every week, says apparently. That's a lot. So, okay, look at Friday. They're all just looking at their calendars to figure out dates. All right, give us a heads up. Family member getting emails. And so I don't even think we would need to seal the entire hearing that we just heard. Then we're going to have some hearing dates on the sealing. All right, thank you, everybody. Have a good weekend. Proceedings concluded at 5:19. All right, so lots of talking for that hearing for some issues that probably didn't need that much talking. But the transcript now unsealed, and inside we see them really debating about things that should have all been done in public. I don't know why they sealed this in the first place, to be honest with you. But we now have it out, and so hopefully this is a pattern that continues. Any of these closed-door hearings and sealed hearings are ridiculous. We're happy that this is now out and publicly available. I don't know that there was anything shocking or dispositive in there, but it's now available to us. We know that there were a bunch of files that were delivered back over in October. I'm sure the discovery has continued on apace. And so we'll keep our eye on this one, but there was a sealed hearing. They talked about shackles. They talked about sheriffs. They talked about the media. And we got rulings that the media will also, just like the sheriff's office, not be made a party to the case, but will be apprised of any attempts to close other hearings and to lock things down. From the prosecution, a little irritated that they want virtual hearings and that they're kind of so accommodating to some of the defense requests. I think that the jury could be easily sequestered after they're already impaneled. And of course, voir dire jury selection will help them identify any problematic jurors who have been tainted in this entire process. So the bending over backwards to make sure that Tyler Robinson is afforded what feel to be like privileges that many other defendants did not get. For example, Derek Chauvin or Kyle Rittenhouse, who were just castigated in the media. We saw photos of Kyle Rittenhouse in handcuffs. He was never convicted of anything. So they can spare us the lecture. But we'll keep our eye on this one. We'll see if the judge ultimately changes his decision. But as it stands, it seems like we have a lot more accessibility than some of what the defense wanted. And we're happy about that. So we'll keep our eye on the Charlie Kirk assassination case with the defendant, Tyler Robinson. Thank you for subscribing and joining as we do. All right, my friends, one final update on the day, and then we'll hear from you and see what you say about all of this. Tim Walz must resign. Lots of pressure now coming down on him. This one from Minnesota Senate Republicans, and look how many signed this document. Whole bunch of them. You can see who is there from all the various districts, and this is in response to Tim Walz enabling the theft of billions of dollars from the American taxpayer. Writing this one, December 29th, they say, all right, commissioners, we are members of the Republican caucus, and we write to you with grave concerns, widespread fraud within Minnesota's child care, autism, home health care services, and more. And if true, the revelations brought to light by the investigative journalist called Nick Shirley highlight obvious misuse of taxpayer dollars and raise serious concerns. Now, in the video, Mr. Shirley exposes a daycare center called Quality Learning Center. They have the N in there. I'm not sure if that one actually had the N. Some of them were Quality Learning Centers, courtesy of the Somalis, which he reports got $1.9 million in tax-exempt funding. Now, alarmingly, the center appears to be non-operational, closed during midday on a weekday, blacked out windows, no visible activities, even misspells learning in its signage as leering. Despite being licensed for up to 99 kids, no kids anywhere, no staff, no child care activities taking place, Mr. Shirley, the journo, provides this as just one example of a similar fraudulent operation in Minnesota. Billions stolen. Now, he documented his visits to several other child care centers that are clearly non-operational. These centers are documented by Mr. Shirley to have billed taxpayers millions of dollars, also blacked out windows, locked doors. During business hours, employees cannot confirm any services. In one instance, licensing records show that the state shut down one center. As soon as they did, a new child center was registered at the same address the following day. Incredible. Now, the video documents a profound betrayal of public trust and a squandering of resources that were supposed to work to help the children and the people who need them. Now, we have oversight in these settings, and the healthcare department is responsible for ensuring that they get the care that they need. This fraudulent entity and more are endangering children, and they demand immediate attention. So all these senators saying, we need answers on this, and you should resign. We've also seen Tom Emmer say that following this bombshell reporting, I'm pressing Tim Walz over his incompetence and lack of leadership. He must answer for the millions of dollars that are being stolen by the Somalis. Tom Emmer, GOP Majority Whip. Now, while the world is just waking up to the chaos in Minnesota, we've been sounding the alarm for years. See it for yourself. He writes, all right, Tim Walz, amid the national disgrace you've inflicted upon Minnesota, I have become further appalled at the recent reports of a blatant large-scale fraud scheme within Somali-run healthcare and daycare centers throughout the state. I demand you take immediate action to hold these criminals accountable. And they're responsible. And for your sake, Tim, I pray you are not complicit in allowing these centers to survive. He was. As you know, Nick Shirley recently traveled there to investigate billions of dollars that were stolen. The amount of this money that was stolen under your watch is $9 billion. Equates to almost the entire GDP of Somalia. And they did it with your help. Just miles away from the state capital, Shirley easily discovered fraudulent Somali-run daycare and healthcare centers blatantly congregating together, sometimes at the same address with no apparent signs of kids, workers, or services. In just a single day of investigating these centers, he uncovered more than $110 million in fraud. Now, it begs the question, how you and your administration were unable to uncover this blatant and rampant fraud over 7 years of, quote, running our state. It's clear you're either indifferent or incapable of doing your job. Now, Shirley quickly found Somali-run Mako Childcare and Mini Childcare Center located at the same address. 120 kids approved for. They got $5 million in public funds, but the building was empty. 1 block away, the same situation occurred as well. Writing, at ABC Learning Center, they're also licensed for 40 children. They got $3 million for the past 3 years. What a joke. They got licensed another one, Future Leaders Early Learning, $3 million. No paperwork at all. The most blatant scheme was Quality Leering Center, which is licensed for 99 kids. They got $4 million over 2 years. They couldn't even spell the sign right. The list of fraudulent daycares goes on. It would have taken your administration minutes to discover these schemes, but sadly for you, ignorance is no defense under the law. So if that wasn't enough, Shirley also found one building in Minneapolis that has 14 Somali-owned healthcare homes at one address, another one in St. Paul, 22 homes at the same address, but none of the businesses even could provide Shirley with a rate. They run $50 to $60 million through the buildings. He was escorted out. He says this is despicable. Now, as he reported, these centers are receiving public funds, including state and federal money, through the CCAP, Child Care Assistance Program. This is especially concerning, given this fraud isn't unfamiliar to Minnesota. Following reports of approximately $100 million in fraud, Minnesota conducted a review and concluded we can't even estimate how much fraud existed in the program. It's because they stole it. Yeah. Therefore, I demand the answers to these questions. Can you list the steps your administration has taken to eliminate fraud? What is your process for auditing healthcare and daycare centers? Have any of these centers been audited? If not, why not? Why was Creative Minds Daycare allowed to operate the next day as Super Kids Daycare? You shut them down, they open right back up. Provide the violations that Creative Minds Daycare received, please. Do you plan to revoke the licenses for any of these people? And if so, do you plan to recommend criminal investigations? Do you plan to do the same? Are you going to investigate criminally any of these people? And Tim, do you plan to resign, given estimates that total fraud is now over $9 billion? Governor Walz, the country is watching. I could not be more grateful to President Trump and his administration for investigating the billions in fraud in Minnesota under your watch. Now, more than ever, I urge you to join him and hold those found guilty responsible, including yourself. America is no longer asking, but they are demanding that you take action against these criminals. I expect your prompt response, courtesy Tom Emmer, GOP Majority Whip, member of Congress. So that is now going out. Tim Walz should resign. If he had any honor, he would, but he doesn't, so he won't. And here is more. You can see that Pam Bondi is now coming out swinging. She says, Minnesota fraud. She said Nick Shirley's work, and she tagged the wrong account, unfortunately for Nick. Wrong account. Spam account. Oops. Says has helped show America the scale of fraud in Tim Walz's Minnesota, saying the Justice Department has already been investigating this for months. So far, we have charged 98 individuals, 85 of them of Somali descent, and more than 60 have been found guilty in court. We're prosecuting more. Buckle up, lawmakers. That's you, Tim. So she writes the following. Let's take a look at what she posted in this thread. I'm incredibly grateful for U.S. Attorney Daniel Rosen and others for uncovering this fraud. Here are a few examples of what we have accomplished here, courtesy of Pam Bondi. 1. Feeding Our Future. Scam 1 got busted. They claimed to serve children of millions of free meals. They submitted fake invoices. To date, 78 defendants charged, 57 convicted. 72 of the 78 are Somali. Diversity is our strength, baby. Bring some more over so they can steal some more billions. Maybe it'll get to $1 trillion soon. 5 defendants are currently fugitives in Africa. That's fine. They can be fugitives over there. Millions of taxpayer dollars were sent overseas to East Africa and the Middle East, our country being ripped off and hollowed out, costing us $300 to $400 million. So the DOJ says we got a conviction. They shared this press release. Let's see what it says. August 6. Today, judge sentenced Farah to 28 years in prison and ordered restitution of $47 million. We're not going to get a dime of that. It's all gone. What happened with this case? Looks like he was originally charged and prosecuted before Trump even came in. So Pam Bondi got a sentence, but in January 2022, that's when the warrants were executed. He had his trial in 2024. So all of this preceded the Pam Bondi DOJ. Now they got a sentence, and that's good news. Just last month, they got another sentence. Let's see this one. Today, we got a sentence. 120 months in prison, 3 years supervised release for $300 million stolen. So not even a long sentence. Now, as demonstrated at trial, when was the trial? June 2024. So once again, this is the Biden DOJ who ultimately brought this case, and the 10-year sentence just came down under Pam Bondi. So that's that one. Now, what else is she sharing? Scam 2, juror bribery. Says, not unlike what you see in the Somali system, they tried to bribe a juror of $120,000 with $120,000, saying if you acquit all of these people, we'll pay you even more. They said, we're immigrants. They don't respect or care about us, so we don't respect or care about them. Bribing jurors. Now, again, this one, Muna Wais Fidin, age 44, charged in a 10-count indictment. And this one does look new. Okay, so this one is new. Saying she got charged today, September 4th. So this is great. So this is a Pam Bondi DOJ that's bringing these charges. 4 counts, federal programs, bribery. This is the 75th person charged. And it needs to be way more than that, man. It needs to be probably like 1,000. 27,000 in kickbacks and more. So that's great news. So that's a Pam Bondi new charge and DOJ prosecution. Here's another one. Okay, so this is an older one. So on April 22nd, 2024, 7 defendants went to trial for their role in the fraud, trying to bribe people. Then they got convicted. So it's an older, April 22nd, they went to trial. 2 of the defendants were brothers. And this guy pled guilty today to his role. So some old, some new in that one from Pam Bondi. Let's see what else she's got. Oh, autism, treatment Medicaid scheme. So they're stealing from autistic kids too. Sick people. Says this guy was charged today by federal information, September 24th this year. This is a Pam Bondi case. Hassan and others carried out a scheme to defraud the autistic. Applied behavior analysis is one type of therapy. So they created a fake company. They defrauded the autism services program, stole money from literally autistic kids because they're Somalis and they need it more. And they are immigrants, and so they don't give a crap. So, all right, so that's from Pam. They're bringing that one. Here's another one. Medicaid fraud, scam number 4. 8 defendants were federally charged with wire fraud this year. Another Pam Bondi deliverable. Charging documents, again, more schemes. Again, going after people with disabilities, stealing from seniors, stealing from people with mental illnesses. The lowest of the low, the scum of the scum, right? You can judge a person or judge a society by how they treat their young, their elderly, and their disabled. How do you treat your young, elderly, and disabled? Well, if you're a Somali, you exploit all of them. You rip them off, steal from the seniors, steal from the kids, steal from the autistic. It's sick. It's like feral. By design, the program had low barriers of entry because they want to help the autistic, but they stole millions, tens of millions of dollars from the people who actually need it. So Bondi said, we are working hand in hand with partners like Scott Bessent, Noam, Turner, LCD, and others. And thank you to Nick Shirley, again tagged the wrong account, and local media in Minnesota for doing the kind of journalism that so many outlets used to do. Can't even tag the account right, but all right, so that's Pam. So some good developments. Oh, here it is. The correct account is with one Y. Thank you for the correction from Community Notes. Anyways, so that's Pam Bondi. They're working hard on it, and we've got some new charges, some old charges, but the media really doesn't want to talk about it at all. You can see we've got Tom Bevan shared this one. Key takeaways from CNN. See anything on there about Minnesota fraud? No, you don't. Nearly 500 women talk about OBGN decades of abuse, Georgia jail. This guy, Fanny, put this dude in jail. Man, that's terrible. Hopefully he doesn't die of bedbug infestation. But nothing there. Okay, they don't care. They don't want to talk about it because diversity is their strength. Minnesota Star Tribune. Snow, an emergency. There's snow in Minnesota. That's an emergency. Having a group of foreigners ripping off billions of dollars, it's like second page news. Tim Walz now taps influencers to spread a political message. Like the Somalis are amazing. What influencers are out there defending the Somalis in all of this? Who knows? But here, the New York Times, also nothing. Venezuela campaign, how Hindu right reshaped America at the New York Times. Israeli leader in a tight spot. They don't care. It's all foreign crap. We care. It's all, like, literally all for it. Israel, Venezuela, India, ICE, Afrikaner, French. It's all foreign. I can't even believe it. Monday, New York Times. Didn't even have anything on it. All foreign stuff. Kyiv. It's an extension of the CIA. That's why. All right. And here's more from the Washington Post. ICE. Hurdles remain in the peace process. All Ukraine constantly. For a trans runner, racing was not a transgender girl. Don't even know what that means, but okay. It must be really hard to run as a trans person. Thank you, Washington Post. French femme fatale, no one even cares about, but that's what the Washington Post is writing about. Meanwhile, our country's being ripped off to the tune of billions of dollars from foreigners. So Homeland is now surging people out, and here was a clip that was shared. They're walking into this little convenience store, it looks like, asking some questions. Don't know what's going on in here. This is what it looks like. All right, doesn't look like like a Somali daycare center. Let's see what this one sounds like.
No. For Valid Lanza, this is the location, this is where everybody comes.
Okay. Are there any subcontractors or anything you guys deal with? Like what say like other businesses that you partner with that you use for a service of any kind, maybe transportation or anything like that? No.
We provide usually parents, and they come like this, drop the kids, they go to us, and then we take care of them.
Awesome. And who actually oversees the receipt of those documents?
Usually like.
Yeah. Oh, my secretary does. Right inside. We've got all the files. Can I come in? No, you can't come in and look at anything. So meanwhile, Tim Walz, as we mentioned yesterday, doesn't really care about any of this because the Somalis are his base of support and political power. So as long as they've got his back, he's got their back. But here, he posted this. He said, "Happy Catter Day." And we happen to love cats here too, like all God's creatures. But it's a little bit weird for the governor to be posting that on a Saturday. So Jonathan Turley had a fun one. He said, I didn't understand why Tim Walz was so excited about his cat. Cats are great, but there's a reason. Tim Walz celebrates Catter Day because his cat is called Honey. Honey just qualified for a $500 million daycare contract in Minnesota. That's why Tim Walz is so happy. Great job, little Honey. Going to be helping all these autistic kids now and children of Somalians, and going to be making a lot of money in the aftermath. So pretty funny. Shout out to Jonathan Turley. We also saw James Comer, representative on the Oversight Committee, was out talking about this, courtesy of Fox News. Here is this clip from Rep. Comer himself.
Well, the most important people are the state whistleblowers, the state employees who put that tweet out that we all are familiar with a few weeks ago that alerted America to the massive fraud. These state employees also allege that they had warned both Governor Walz and Attorney General Ellison for years that this fraud was occurring, and yet nothing was taking place. So we're going to bring the state employees in. We're going to get their sworn testimony. We appreciate their bravery in coming forward. We're also going to bring in state lawmakers and Minnesota mayors because the walls are caving in on Tim Walz. This massive amount of fraud is affecting and impacting every citizen of Minnesota because they're having to cut services because so much of the money for social programs was wasted and defrauded by this Somali population. So these are the people we're going to bring in. We're going to try to identify who was responsible for this. We're going to try to identify banks that we can subpoena their bank records so we can follow the money to see how much was taken, who took it, and then who do we need to hold accountable, and hopefully we'll have some criminal referrals at the end of the investigation.
Criminal referrals for whom? We want the politicians who are enabling this to be indicted. We want the Ilhan Omars, the Tim Walzes, we want the Keith Ellisons, the people at the top who are getting the benefits of this entire scam, who are looking the other way and enabling it. Tim Walz changed the flag of Minnesota to represent Somalia versus the citizens of Minnesota. So he is in the thick of this. We need some people to come out and reveal the truth about it, disclose the emails, disclose the texts, come in and testify and explain how corrupt these people were. They had their hands in the cookie jar. They all got caught. And now all they want to do is talk about racist, white supremacists and bigotry and xenophobia. I don't care if it's white people stealing $9 billion. We don't want it. We don't want that to happen across the board. By the way, there are a lot of white people stealing billions of dollars from all of us. They should be prosecuted too. We've said that for years. But in this case, this was imported. We don't need to import fraudsters. We don't need to, on the back of browbeating Americans into being good people, diverse country, whatever that means, allowing our country to be ripped off, hollowed out, actual citizens like seniors, students, autistic kids, all getting ripped off by the Somalis who think that this is their country now. I'm the president now, and they run the treasury. So it's sick. Tim Walz belongs in jail. So does Ilhan and Keith Ellison. We hope that happens soon. James Comer hopefully gets some evidence, refers it to Pam, and she can add it to her tweet thread, and more charges can come. So we'll keep our eye on this one, my friends, and see if impeachment proceedings start or if more demands for resignations come from the Minnesota Senate. We'll be here to cover it. Thank you for subscribing and joining as we do. All right, my friends. What a beautiful stream it has been. Thank you for joining us extra early. We're here in Washington, D.C., and so this afternoon, we're keeping the calendar cleared out so that we can get over to the Brian Cole Jr. in-person hearing today at the D.C. Federal Court. So that's where we'll be this afternoon. Then we'll do a recap video, and we'll post that later this afternoon. So thank you for coming back and checking that out to see what happens at the hearing today, presuming it all goes according to plan. Now, quick recap, then we'll see what you have to say about all of this. We did spend some time on Brian Cole Jr. this morning, read through his defense motion where they confirm for us that he does have autism, level 1. He also has OCD, and they're demanding that he be released today because there's no probable cause. So we'll see what the judge does. We learned about what level 1 autism means and how it works, and read through several character reference letters on behalf of Brian Cole Jr., where everyone is saying doesn't resemble the guy that we know. Then we looked at the transcript that was just unsealed and released with some slight redactions in the Charlie Kirk, Tyler Robinson assassination case. It was less interesting than I thought. Don't know why the whole thing needed to be under seal. Couple things about some security protocols, maybe some suicide conversations, whatever. But the judge unsealed most of it because it shouldn't have been sealed in the beginning. We went through it. Don't think that there were any major surprises that jumped out, but now we have the record that was conducted in a proceeding behind closed doors, which should not be happening in this case. So we're happy about that. Then we talked about the pressure mounting on Tim Walz. We've got Tom Emmer, who is the GOP whip, who is in Minnesota, saying, "You need to resign, Tim. Do you plan to resign? If not, why not? Let me know." Read through that, looked at the senators and what they're working on. Heard from Pam Bondi. She says, our investigation is surging in Minnesota. We've got the media covering up the whole thing. HSI agents now going around knocking on doors. Are any YouTubers bothering you? I wonder if they're asking that. Are any YouTubers coming around? Okay, let us know. We'll go deal with them. Jonathan Turley making fun of Tim Walz, whose cat got a $500 million autism contract in Minnesota, which is great. And James Comer now saying, we will investigate this and make criminal referrals where appropriate. So all that is good news. But now, my friends, it is time to hear from you. And let's see what you say about all of this and more. Happy Tuesday. Week is coming to a close. Year is coming to a close. And boy, it's happening fast. We got a couple of donos in here today. What's up, Carrie B, K Bean? Clipping for us on the day. Thank you both. Muffin Rando, I see you. Nice to see you. Hey, look at this handsome wiener dog right here. Happy Tuesday morning, baby. He's excited as we are to go to the Brian Cole hearing. He's going to be excited too. Jammin'. What a beautiful day. Hey, Leonard. Leonard says, corrupt Dems and media keep lying about Trump's competency. This is disgusting. The fact is, Trump is incredibly strong and incredibly sharp. I've seen a lot of that. Yeah, I've seen a lot of that, Leonard. A lot of like pictures of his hands, like bruising. They're saying, oh, it's bruising. He's like dying. He's going to be dead in a minute. He's totally gone. It's really rich coming from the people who said that Joe Biden was like spry. He was doing backflips and handsprings back there with Kareem. Jen Psaki, he runs circles around me. Jen, he's not running anywhere. He can hardly stand. So it's just like anything. It's confession through projection. I think that they know that their side, their guys, were all invalids, and they have to make the accusations against the other side because it's what's happening with them. Leonard, God bless President Donald J. Trump. Amen to that, Leonards. Thank you for that. We agree. Hey, what's up, user? User XR9XY8DB7R. Welcome. Welcome to the community. We're happy to have you here, and we'll see you in just a few minutes on our members only after party, baby. All membos stick around because we'll see you in a few minutes. Hey, Kantamitsu. What's up, Kantamitsu? We got, says, Walz reminds me of Ephialtes, the traitor in 300. Oh, that's a really good one. He looks almost exactly like him, actually. Did Tim Walz play that guy? Was he an actor in that film? Kind of the hunchback, the balding, the bulging eyes. Yeah. It's a good one. It might actually be him now that you mention it. Hey, Off-Label Podcast says LTM's son Gus has genetic disorders that makes Gus mentally defective. Tim's genetics are defective. So in conclusion, Tim Walz is restarted. There's a lot going on there, Off-Label Podcast, right next door. Thank you for the dono. Tim's son, Gus. I know. Yeah, he started crying in the camera. It was like, that's a little weird. You're like, maybe something's wrong with him. Didn't want to make too much fun of him because like maybe something's wrong with him. But that all makes sense. It's inherited. Tim Walz is restarted. Yeah. Hey, and 51K. What's up, 51K? How are these people hiding the money they get from the IRS? I can't imagine they just keep their cash in homes. If that were the case, they would mass home invasions from other Somalis who know about the scam. How are they able to hide this excess of income? Well, that's a great question, 51K. And there's probably a rabbit hole that goes much deeper than anything we even know. There's a story about Ilhan Omar and her husband, and how her husband started like a hedge fund and is now managing like billions under management. So maybe there are financial structures and institutions to which they are funneling these materials, and they're getting away with it because it's not like they're just like Fannie Willis putting cash under their mattresses. It's all, the facilities are just one part of it. Then they take the money they get and they do something else with it. You read in one of the charging press releases that they're sending millions or billions over to Somalia. So they're just, exporting it, probably with the IRS Just lying. Probably just saying they have all these business expenses. Oh yeah, we have to manage 99 kids. So we made $3 million, but we spent $2.9 million. And so the $2.9 million is all deducted, and then everyone gets paid a small salary and to run the company. And the IRS is like, well, they're doing great work. Look at all these autistic kids who are getting treatment. We're such good leaders. All the politicians say, we're doing such a good job. We're saving so many autistic kids. No, you're not. You're paying for Ilhan Omar and her husband making all sorts of money. So I forget what that story, like Ilhan Omar husband. Yeah, like here's the story from Fox. Husband's companies surged in value as Minnesota reels from a $9 billion fraud. A pair of companies owned by Tim Mynett, the husband of Ilhan, after she divorced her husband, a brother, have exploded in value. They've grown more than 20 times in under a year. Weird. It's a picture that is strange because they stole $9 billion. These are revelations about her husband's company exploded. Omar also disclosed evaluations of Rose Lake Capital. In 2024, it was between $5 million and $25 million. Okay, her husband's company between 5 and 25. Just 1 year before, it was worth nothing. $1 to $1,000, nothing. Then a year goes by, all that Somali money comes in, boom, explodes. Congressional disclosures and more. Bunch of other lobbyists for Obama are a part of that organization. Mounting fraud, there's her husband. Similarly, another company called EST Crew, a winery, reported a value between 1 and 5 million. It was previously just 15,000 to 50,000. So money laundering, it's probably just money laundering. Phone number on the website doesn't work. Nobody's answering any questions about this. They're just laundering money. Sick. And our government's just like, well, diversity. We can't wait for more. My friends, thank you for sending those in. Great comments, great donos. What a lovely day and a lovely stream. Let's say hello to our friends on X, and then we'll bounce over to our members only after party, and then we're hitting the road. We're going to court this afternoon. I got court this afternoon. Haven't said that in a long time. So that's fun. Shout out to our friends on X. We got I Am Back. Says, so what? Autism doesn't mean he doesn't know what he was doing. Autism is indeed a very broad spectrum. That's true. Autism could mean that he didn't know what he was doing, but it doesn't necessarily mean that. So, but it is an interesting factor to consider. And I think the autism thing is more concerning during the interrogation. If you're interrogating somebody who's got clear autism, I think that the reliability of anything that comes out of their mouth is lessened. So I think that's the so what there ultimately. But I agree, because he's autistic doesn't mean that he is innocent. It's not a one-to-one connection. It's just another factor that we consider amongst many other factors. And if he was not autistic, then I think that the confession would be a little bit more reliable. And I mean, I think you can say, what was like Ted Kaczynski? Was he autistic or something? Right? Guy was like off probably, but I don't know if he had a formal diagnosis, right? So you can be autistic, you can be unwell, you can be schizophrenic and still commit crimes. It just is an interesting factor in the analysis when one of the key bits of evidence in this whole prosecution is his admission. Like, okay, he's autistic. He can't, and he had nobody helping him during the interview. Doesn't mean he's innocent, but maybe he is. We'll have to see. And it's very convenient that they just nabbed him right after they pointed at the other gal. All right, so great comments. Good to see you. Shout out to our friends on X. Retired 5-0. Ted K is my boy. Yeah, a lot of Ted K fans out there. Minus, the death and the mayhem. But he had some interesting things in his manifesto for sure. Cam U. Did you see the phone number for one of the daycare centers goes to Tim Walz' office? No, I did not see that. That's pretty hilarious. Pretty hilarious. Now, Tim said we could run this place, so just call him if you have any problems with it. Oh, go talk to Tim Walz, FBI, HSI. Good stuff. All right, so my friends, we'll pause here for the day, for the morning, and we'll very likely, presuming the court doesn't get continued and all the things, have an update on the Brian Cole Jr. hearing. So we'll post a video hopefully later tonight, get it all done and posted from what went down in there today. Detention hearing, preliminary hearing, whatever it is, we're going to wrap up, get out the door, and go over there. But not until we spend some time with our amazing membos, baby. So we're going to head to our members only after party. If you're a YouTube member, stick around, should automatically transfer you. If you're a locals friend, hang tight. We'll be right back in a jiff. But my friends, it's been a beautiful stream. Thanks for joining us early and being with us as we're bouncing around DC. We, of course, will be coming back here tomorrow, and we're going to get into it again. Before we do that, big shout outs to our amazing mods and meme smiths who help out around here, including K Bean in the house. We got Carrie B modding the fort down for us. We got Muffin Rando also helping out today. Big shout outs to Donut Mind Me, to John, to Janak, Neuro D, Dog Digger, our friends Gigum, Elliot, Just Rhonda, all helping out around here. Very grateful. And thank you, my friends, for being here, for your viewership, for your subscriptions, if you haven't already done that. So we never miss you again, because I don't want us to be apart, ever. All right. So we'll come back in the morning. In the meantime, it's after party time, so Membo, stick around. Otherwise, my friends, thanks once again for being here. Covered some good stuff. Cole, Kirk, Minnesota. We'll be back tomorrow with even more. So hopefully we see you then. But until we are back here tomorrow, I want to wish you the best and most beautiful day possible and invite you to come back tomorrow, because in order to do the show appropriately, we need to see you right back here so that together with your help, we can shine that big, beautiful spotlight of accountability and transparency down upon our system with the hope of finding justice. Make it a beautiful day, my friends. We'll be right back here tomorrow. We hope to see you then. Until we are back, I hope you're out there making it a great and beautiful day. We'll see you back here tomorrow. Be well, and bye-bye.
Thanks for watching, my beautiful friends. Now it's that time where the stream must end. We brought the heat with every chat and line. Together we exposed corruption. One more time we dove in the truth where the media hides. Lit up the lies with receipts on all sides. The fight isn't over, but we made them sweat. We ain't done yet, no, not just yet. Because together we are watching the watchers. Truth on our side. Watching the watchers. We won't be denied. Watching the watchers. Eyes open wide. Fighting for freedom with nothing to hide. Drop a like and don't forget to share. And bring a friend who's ready to care.